sign a state document for a heterosexual couple, you have to do it for a same-sex couple.
Okay, so the question is, because you sign a marriage license and it's filed, if you sign it for heterosexual couples, could someone say, well, you can't discriminate, you've got to sign it for same-sex? I don't think so, and again, it's the First Amendment versus the 14th. You have the absolute right under the Constitution and all the case law that's out there to have your personal religious convictions, and that's protected by the Constitution. Does that mean you won't get sued? No. There are people that'll sue you over anything. But I'm convinced that right now, if a pastor says, I'm not going to perform same-sex marriages, he'll win every time in court. Now, unless you're in San Francisco, you might lose at the lower level, but if it's appealed up. Right now, religious liberty has been protected. And the Supreme Court has not ruled on how all this works its way out. But I don't think you're going to have any problem if you as a pastor say, I don't perform same-sex marriages. But you're going to be in a better position, stronger position, if your statement of faith, your bylaws, and everything at the church says that. And you have a policy for the church that says we don't do same-sex marriages. So could you be sued? Yes. Are you going to lose? I doubt it.
I would add that most pastors already discriminate and do not do certain weddings for other groups. For example, many pastors would say, I do not perform weddings for couples where one is a professing Christian and the other one is not. And so you have already established a pattern of ministerial discretion about who you're choosing to perform the ceremony for. And I think that could extend to what you're describing here as well. I don't think you're obligating yourself by doing that.
And final comment on that, we have to realize there are going to be lawsuits filed. Just because somebody files a lawsuit or a government official says you can't do that, we have got to fight these battles in the courts all the way to the Supreme Court, and they then are going to lay down the black and white of it. That hasn't happened yet, but you're on very strong ground.
And this raises another issue, if I might just comment on that from your question. I actually had a trustee who wrote a very eloquent, frankly, paper for us about this, about his raising the question of should ministers in the United States stop performing weddings legally, all right? And his position was that in the rest of the world, most countries of the world, Christian ministers do not sign marriage licenses. No minister does. It's a purely legal document. So, for example, in other countries, a couple would go down to the courthouse, they would file their paperwork, they'd sign it, and they'd be declared married in that moment. Then that evening or the next day or whenever, they would have a religious ceremony in which the religious officiant would conduct a religious rite in which they would be pronounced husband and wife in the eyes of the community and God. But their marriage took place their legal marriage took place when they signed the document the day before. Now, he was simply saying that this may be the solution for us. That if we find ourselves losing on the legal front, that we may make that choice to just simply say, fine, we let marriage be a legal contract, but we perform something that is more of a rite of the church type project, like a baptism would be the same kind of an idea. That's his. I found the paper intriguing, quite frankly. I don't think we're there yet, but he was simply pointing out that most of the rest of the world is there, but not because of this reason. It's just because most of the rest of the world does not recognize ministers as having the legal authority to sign the marriage licenses anyway. So we may be going to that place. So just a thought.
And that's what we do at our church.
Yeah.
Yes.
We believe in the separation of church and state.
So you let them sign and then you just do this ceremony.
What they do down in the courthouse is their business. What we do in the church house is our business.
We are recording this, so if you have a question, we're going to give you a microphone. Question right over here.
I just had a question in regards to use of interns. Interns that are coming from out of state, out of area, that are volunteers, that are not technically employees, and then also interns that are working under a counseling intern licensed by the Board of Behavioral Sciences examiners for counseling purposes. How do we write into our, I guess, I'm assuming the bylaws and job description is part of that, but can you speak to that a little bit more?
Sure. Now, so this is a volunteer position in a counseling ministry in a church. Is that what I'm hearing? So, yeah. So you have interns that are volunteering. They're not paid, but they basically, an intern has to come under a couple different, they're still an employee or they're an independent contractor. There's a classification process that goes through. But if you engage an intern, they're basically being employed by the church, and you can ask them to submit the statement of faith. You need to put that in what they're doing. It needs to be in there that this intern position is for this purpose, youth ministry, counseling, but the intern recognizes that the church has a statement of faith and that they are not in serious, or they're not in disagreement with it, and they agree to conduct themselves in a manner that's consistent with it. I will say you're going to begin to get more and more young people, I believe, in our churches that are going to be questioning this whole sexual orientation, same-sex thing, and so the church is going to have to discuss, is that a basis we're going to say no on? But because once you start compromising, and if you let an intern not do the statement of faith, now you're started down the slippery slope. Yes, Attorney Davis, give him a microphone. You have one? Go ahead.
As unusual as it may be, Supreme Court decisions are not final. Why? You can amend the Constitution. Has there been any movement in the Baptist religion groups on why can't we start a motion or movement to amend the Constitution to define a marriage as a relationship between a man and a woman?
You could do it on the national level. We did it in California. I don't want to go through the whole history, but the bottom line was the California Supreme Court ruled unanimously that Prop 8 was legal. I don't know if you know that. They ruled unanimously. And then when the lawsuit started in San Francisco, and the state attorney general, the governor, nobody would step up to defend the lawsuit. They all said, no, we agree with the plaintiff. We went back to the California Supreme Court and said, well, Your Honors, we need to have standing to defend that lawsuit as the proponents of Prop 8, because if we don't defend it, that means the governor and attorney general can veto any law they don't like. They just don't defend it. And the U.S. Supreme Court said unanimously, you have standing to do it. We then defended it all the way to the U.S. Supreme Court, and the U.S. Supreme Court said you don't have standing. So we're living in a very difficult legal environment. So it's important that we stand up and we be consistent. So back to your question. I know we got sidetracked, but back to your question. I think you've got to be consistent with volunteers, like if you have job descriptions for teachers or what a policy is on teachers, it needs to be the same for teachers as it is for interns and others. And you should be all right. Other questions? Over here.
Yeah, thank you. We have, I come from a Hispanic church. Everything we do is in a Spanish language. Does the state require that every legal document needs to be written in English? Like, for example, our bylaws are in Spanish. Do we need to have that in English and all of the legal documents that correspond to that?
No, you don't. Your articles of incorporation have to be in English because you have to file them with the state. But your bylaws can be in your language because they're not filed with the state. What will happen is if there's a dispute and you have to go to court, there'll be an interpreter, and those documents will maybe have to be interpreted then, but as long as your people can read them and understand them. Now, the problem becomes, do all of your members read and understand Spanish? Because you've got to have it in the language that they understand and they can be held accountable for. Okay? Other questions? Yes, up here in the front.
Maybe in your employment policy that we should write in a religious statement for every job description. How do you defend yourself in the case of hiring a custodian, for instance, rather than a teacher?
Okay, and it's a great question. He said, I'm recommending that you put in every job description legal requirements, that you want this person to be able to pray with people, to understand your faith, and not be in disagreement with your message. He said, well, what about a custodian versus a teacher? That is the issue that's in the courts and that the law differentiates. Cal Baptist University, they have a much more difficult time saying we want our custodians to be people of faith. A church is exempted from the laws that deal with employment discrimination, okay? You can hire people that you can say, we want all these people to be members of our church. So you can discriminate. The law allows churches to discriminate. I'm saying put it in the job description to make it absolutely clear. So back to the custodian. This is a matter of practice. Do you want to hire a custodian to clean? Maybe you hire an outside service. You don't know that they're Christians or not if they come in and clean your building, right? But if you want to hire a custodian, you may decide it doesn't matter that they're a Christian. But if the custodian's going to open the door for people, if he's going to constantly be in contact with the church members, working with the church members, you can make it put it in a statement that we want this person to be a member of the church or to be a Christian. You can do that in the church, and I don't know of any churches that have been sued because they require their custodian to be a Christian.
Also, you could make a case for church support workers, like, for example, who interface with children in child care settings or other things, and you could make a case for wanting the person to have certain character qualities or certain standards of behavior that would relate to that. So there are ways to do it. The churches, it's not that big of an issue, frankly. Where Phil's mentioning is that those of us who work at schools or nonprofit ministries that are Christian or that are sponsored by churches, that's where it gets much murkier. Right. And I will say that, like, for example, when Golden Gate was in the Bay Area, we had a very difficult time with support staff employees because they were in such high demand there, and trying to find the ones that were Christians, not Christians, all that kind of thing. So it can be very difficult, but not so much in the church. You have a much easier time of it. Mm-hmm.
Question?
What if your church facility is being used for community activities like voting booths, or maybe some other type of community-based activity? What would be your advice?
I think, again, you need to have a policy. Now, it doesn't have to be complicated, but it needs to, and this policy, if you look at it, talks about it. We do make our facilities available for public events such as voting or school events, and you can put it in there. But we reserve the right to not make it available for any activity that we believe violates our statement of faith. So you need something. If you're going to offer it to the public, you need something in writing that makes it clear that you have a right to determine if this violates your statement of faith or not. Okay? Question over here.
You had mentioned being consistent with the enforcement as we're building our articles and our doctrine and everything, or to be consistent in the enforcement of it, to help you with the applying it.
Yes.
So are you saying, just so I can understand it, if we're building these to protect ourselves in regards to volunteers and employment, we build it so that we're not hiring individuals that are homosexual? Is it not a double-edged sword when we talk about divorce? You know, does that mean we don't have volunteers that have been divorced?
Great question.
How does that work?
Well, what do we believe the Bible teaches? I love the verse from Corinthians that says, "Such were some of you." So what's the difference if someone's been a murderer or somebody's been whatever? The difference is they've repented and asked forgiveness. And so what the homosexual community wants is us to accept them in their sin. Now, with adultery and with divorce, I don't think we talk about this enough. Very frankly, I think we're becoming so accepting of it that I haven't thought through it and I haven't written it all out. But I think we're going to have to begin to define some of those things. You have to understand, I'm talking based on experience and based on my expectation of what's going to happen because there are no cases on these things yet. So I would simply say that where you say we allow these kind of activities, you define based on your statement of faith and simply say that pick a body, your church council, your pastors, your elders, your deacons are the ones who determine, are the final determiners of whether or not it violates that or not. Your question was, can we get ourselves in trouble if we discriminate on the basis of same sex but not on divorce? And my comment was, I think you can. How you put that into writing, I've not done yet, okay? And so we're all in this together trying to figure it out. But I think basically you're better off using generic language. Put your statement of faith there and say, we do not allow activities that violate the statement of faith. And our deacon board is or the church council or the pastors or the final, they make the decision on what does or doesn't violate it based on our statement of faith. That's all I can tell you. Other thoughts? Or?
When I talk about consistency, I think it's important for us to recognize that we're all going to make mistakes about these things. Having been on the wrong side of a number of different legal claims over the years, but having so far had them all resolved satisfactorily. And the reason that we've had them solved satisfactorily is because in every case, when things started unfolding, it became evident that the ministry had made reasonable accommodation, or had followed reasonable practices, or had consistently applied its position. What you want to avoid is gross inconsistency, where you say, for example, that you're not going to do something until your brother-in-law needs it done, and then you hire him. Well, now, that's the kind of thing that causes lawsuits to be lost, is because you've made a gross inconsistency. So there are going to be difficulty, but strive for congruent doctrine, policies, practices lined up as much as possible, recognizing there may be variation, but as much as possible. Over here is a question, I think.
Yeah, this may be beyond the scope of our discussion today, but I think
we can do it.
Okay, you can do it. I think there's an erroneous belief that because of this phrase, separation of church and state, that churches should not be involved in any kind of political activity. We should not be doing any kind of petitions or involved in any referendums, signing any papers, Prop 8, SB 1146, Can you address that a little bit? I mean, as a pastor, I don't want to stand in front and try to train people on the First Amendment rights as a church, but I mean, what can we do? What cannot we do? We understand that thing about not endorsing candidates, but beyond that, what?
Well, first let me say this. Again, let's go back to the Constitution. What does the Constitution say about religion? Now, you have to understand this. Congress shall make no law respecting the establishment or free exercise, okay? Prohibiting free exercise. It doesn't say anything else. Now, the only reason that we're told as churches we can't endorse a candidate is why? Does the Constitution tell us we can't? No. Many years ago, Lyndon Johnson got the Johnson Amendment passed because he was upset with some nonprofit organizations who were opposing him when he was in Texas. So he got Congress it was a rider to another bill. And so Congress passed and the president signed into law the Johnson Amendment that says if you're a 501c3, you can endorse. Now, do you realize that law has never been challenged in court? And so what's happening? They've used it as an intimidation. I say the other side. They've said, pastors, you can't. Pastors, you can't. And so we're fearful. In recent days, the Alliance Defending Freedom and others have challenged pastors. Now, I'm not saying you should, but I'm saying to challenge them if you want to talk about elections and to talk about what candidates believe. Rick Warren had his forum. I thought it was great. And here's what's happened. And then it say, send us a tape of the message. And they've sent those tapes to the IRS. You know what the IRS has done? Nothing. You know why? I think they know they're going to lose if this ever goes to court because what? What's the First Amendment? Congress shall make no law expecting the free exercise of religion. So that's first and foremost. I want you to know that issue has never been decided in court. Just a minute. Secondarily, though, right now, the law says you're not supposed to endorse a candidate. You can have forums. You can have the candidates, if you want, speak. You can put out what are neutral election documents. You can speak out for any issue that you want to talk about. Now, here's what I'm recommending, and I didn't bring it today. I thought of this later. I've written a bylaw section that explains what you can do, and you can put it in your bylaws, and now you've got a document in your bylaws that says, we believe that silence and inaction in the face of injustice is wrong. Therefore, we reserve the right to speak out and act on any issue we want at any time. I mean, that's the language that you put in a bylaw. Because you're right, members and pastors have been intimidated so long, they're fearful. Well, we're getting pushed in a corner, and so my answer to you is, first of all, the Constitution does not prohibit you doing anything. If you as a pastor wanted to, you can personally endorse, you can stand up in your congregation and say, I want you to know that I'm voting for so-and-so if you wanted to. I'm not saying you should, just saying you can. But the church is not supposed to vote to endorse a candidate because of the Johnson Amendment, not because of the Constitution. I will tell you, in the early days of this country, the Black Regiment, the guys that stood behind the pulpit, preached all of this stuff. They preached about candidates who you should vote for. They, in fact, enlisted people to run. And we've gotten this idea we can't do that anymore. Well, the only reason we can't is because we haven't stood up and fought for the right to do that. Right?
Amen.
All right. Do you have just a quick comment?
No question. What, if any, position do you have of us including into bylaws and agreements an arbitration clause so we don't have to go to the court?
Okay, so let's say you do get sued. And so somebody that wants to use your facility sues you. Under law, you go to trial. The only alternative is the courts if there's a lawsuit. But if you have an agreement, if you have a facility use agreement, and in there you have an arbitration clause that says, we're not going to go to court, we're going to go to arbitration, the law recognizes any agreement to arbitrate. So arbitration can be a better alternative in some disputes, but in many of these disputes involving religious liberty, we need to go to the courts. Now, I'm just saying that I was a litigator and I've never sued anybody in my life. So I'm not into suing people. But the only way to resolve some of these constitutional questions is to take a case to court and all the way to the U.S. Supreme Court. Does that make sense? So we've got to be wise on when to do that. I don't think we go around suing people, but neither do we let them just walk right over us, because I'm telling you, their objective is not just to be nice and get along. Their objective is to put us out of business. So I've got, you asked specifically what you can do. I've got a list of what you can do. I've got a publication on that. I don't have it with me, but I got my card back here. I'll be glad to send it to you. Okay, so I'll give you my card.
Good. Last question. Michael.
The question I have, and I believe that you've addressed this, but I want for peace of mind for what we do at the association office. Since last year, we've tried to educate ourselves on this so that we can help churches how to protect themselves, how to set their house in order in terms of bylaws and usage agreements and such like that. What we have done, or what we've encouraged, and I want to get either an affirmation or a correction from you on this, what we've sought to do is help churches understand that because of the foresight of our denominational leaders in the Baptist Faith and Message 2000 that added articles on definition of marriage and religious liberty, that we've encouraged them as a part of their membership policy to have people agree with the Baptist Faith and Message 2000 in principle and practice. And then when it came to facility usages for groups that were outside of the congregation, outside of membership, that they would sign a document stating that they are in agreement in principle and practice with the Baptist Faith and Message, having them, have a copy of that. Is that good policy and good practice to bring things in alignment, or is there more that needs to be done?
No, that's the simple approach to take. Now, what you're saying, though, is this. We're not going to make our facilities available to anybody that's not in agreement with the Baptist Faith and Message in principle and practice. And that's one line to draw if that's what you want to do. Some churches actually want to allow non-believers and others to have meetings there and use it as a way of reaching out to people, whether it's allow them to have weddings there or have a club meeting. So yes, if that's where they want to draw the line, that's perfect. Because you're saying, no, our properties are dedicated to only be used for activities that don't violate this by people who don't violate this. Do you see? That's where you've drawn your line, but you better be consistent with it. But not every church is going to draw the line the same place. Some people will say, no, it's our facilities are for members only, like that exclusive country club. Others are going to say, no, we're going to have activities for members, we're going to have activities for the public, we're going to allow people to rent it. So it gets a little more complicated than one size fits all, but that will solve it if you say, no, our facilities are only available to people of like faith and practice. And they have to sign a statement that that's true, and if you're not, you don't get to use it. You should be all right if you want to draw the line there.
Okay, thank you. Michael, you want the last word?
I want to thank you all for coming. I want to thank both of these men for their presentations. We've taken this and recorded it, and we're hoping to make it available on the website at the Orange County Southern Baptist Association, because we know that we've still got pastors and church groups that wanted to be here. They've got VBS going, or they're on vacation, different things like that. The document that Phil had passed out on Protect Your Ministry, we have that available at the association office in digital form. If you didn't get a copy, or you would like a digital copy of that to be made available to your church members or to your leadership group, mproud@ocsba.org. That's my email. Let me know, and I'll send that digitally to you. We have lunch available. Roger, I want to ask you to come up. If you'll come, and maybe you've got a word for us, and then bless our lunch, and then we'll be dismissed for that. All right? Thank you.
Thank you. Let's pray together. Lord Jesus, we appreciate all these things that you have added to our understanding today. We're thankful for the privilege of gathering together as your people to learn and to know how to better prepare for the ministry in the future. Thank you for Dr. Iorg. Thank you for Dr. Kell coming to help us understand. And we thank you for lunch. We thank you for your provision of life today. In Jesus' name.